Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss a very important case which has recently been decided by the Madras High Court in the case of MARG Projects and Infrastructure Limited versus Deputy Commissioner of Income Tax. This case has been decided on 30th June 2022. This case is regarding a writ petition filed by the assessee after a search on the assessee under section 132. When the search was conducted on the assessee, the Benami proceedings were initiated against the assessee. The initiating officer issued the notice to the assessee that why some transaction should not be treated as Benami and why your property is not treated as Benami property. The assessee asked from the department that please provide me the copy of the statements which you are relying and also give me the opportunity of cross-examination of those persons on whose statement you are relying. But the initiating officer did not provide these documents and neither provided the opportunity to cross-examine. But natural, when this information is not with the assessee, how the assessee will present himself before the initiating officer also in a proper manner. The initiating officer provisionally attached the property under section 24. This provisional attachment is for 90 days. If the initiating officer wants to continue this attachment beyond 90 days, then the initiating officer can do it with the permission of the approving authority. So in this case, the initiating officer, after taking the approval from the approving authority, extended the provisional attachment. The assessee was not given the copies of the statement, not being provided the cross-examination of the persons on whose statement the department was relying. The assessee was left with no option other than going to the writ court. The Madras High Court in this case said that the assessee has not provided the proper explanation before the initiating officer for the satisfaction of the initiating officer for the Benami transactions. And there is no law, there is no provision in the Benami law in which the assessee is to be provided the copy of the statements and the opportunity of cross-examine. There are a number of the laws in the income tax also where there is no specific requirement of cross-examination or providing all the documents to the assessee, but it is through all the court's decisions, court's judgments, that in the interest of the principle of natural justice, that these documents and these opportunities should be provided to the assessee. But in this particular case, the court said that there is no provision in the Benami law to provide these documents at the stage of initiating officer. The initiating officer has to primarily satisfy that these are Benami transactions, and if the assessee wants to exercise his right of asking these documents or the right of cross-examination, then he can do so before the adjudicating authority. But at the level of the initiating officer is not required to provide all these documents to the assessee at that particular time. So, meaning thereby that the initiating officer was very correct in provisionally attaching the property beyond 90 days by taking the approval from the approving authority. Friends, this case is very harsh because according to me, if until and unless the assessee is with the information that who has given the statement against the assessee and what documents the department is relying, then how the assessee will present himself or herself before the initiating officer in a proper manner? If these documents have been provided to the assessee at the time of the proceedings before the initiating officer, then there will be no prejudice to the department. But with due respect to the Madras High Court, my humble opinion is that this case is very harsh, and if this type of decisions will come, then the department will use these cases in their favor and those documents will not be provided to the assessee, which should be provided to the assessee at the time of the proceedings before the initiating officer. Although there is no specific requirement into the law, but there are a number of the cases which says that these documents are required to the assessee for preparing his reply, for preparing his submissions before the initiating officer. But at the end, this writ was dismissed by the Madras High Court and no relief was given to the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is MARG Projects and Infrastructure Limited versus Deputy Commissioner of Income Tax.